Hi, welcome. In this video, we will be explaining Part 5 of the Communications and Multimedia Act 1998, Act 588, which is Powers and Procedures of the Malaysian Communications and Multimedia Commission. We will start with Chapter 1, Directions. In exercise of the powers conferred by Section 169 of the Communications and Multimedia Act 1998, Act 588, the Commission issues class assignments for 5 different devices. The citizen band communication band is specified in first schedule. The cellular mobile access device is specified in the second schedule. Third schedule specified the leased channel radio access device. The fourth schedule specified the spread spectrum device, while the fifth schedule specified the trunked radio access device. A person who fails to comply with a direction of the Commission commits an offence and shall, on conviction, be liable to a fine not exceeding 300,000 ringgit or to imprisonment for a term not exceeding 3 years or to both. Next, we will talk about Chapter 2 Determination. A determination is conducted by the Commission. Several rules are needed to be followed. First, the Commission shall determine the matter within 45 days from the conclusion of the inquiry. Next, an inquiry shall be carried out in accordance with Chapter 3 of this part, and at a standard and in a manner consistent with the provisions of this Act and its subsidiary legislation and any instrument issued, made or given under this Act. Besides, a determination made by the Commission under this chapter shall be registered as soon as practicable. For Chapter 3, we will explain about inquiry. The Commission shall, in response to a ministerial direction, hold a public inquiry on any matter of a general nature which relates to the administration of this Act or its subsidiary legislation which will serve the objects of this Act with 2 conditions. First, in response to a written request from a person, or second, on its own initiative, only if it is satisfied that the matter is of significant interest to either the public or to current or prospective licensees under this Act. For report on an inquiry, several rules need to be followed. The Commission shall publish the report, setting out its findings as a result of any inquiry it conducts. Besides, the Commission shall publish the report within 30 days of the conclusion of the inquiry. On the other hand, the Commission should not include any material that is of a confidential nature in the report. Here comes the Chapter 4, which we will talk about investigation for purposes of administration, inquiry, etc. The Commission shall investigate any matter pertaining to the administration of this Act or its subsidiary legislation given 2 conditions. First, if the Minister directs the Commission to conduct an investigation into any civil or criminal offence under this Act or its subsidiary legislation which may have been or may be committed. Or second, if the Commission has grounds to believe that a civil or criminal offence under this Act or its subsidiary legislation was, is or will be committed. Investigation requires 4 different stages. It starts with complaints to the Commission by a person. Next, if the Commission decides to investigate further, investigation will be conducted. After concluding an investigation, the Commission may prepare and give to the Minister a report. The report shall cover the conduct of the investigation, any findings that the Commission has made, the evidence and other materials on which those findings were based or any other matters relating to the investigation. Finally, the Minister may direct the Commission to publish a report of an investigation if the Minister is satisfied that the publication would be in the national interest. We will proceed to Chapter 5, which is Information Gathering Powers. Notwithstanding Section 53, a person who fails to comply with a direction of the Commission under this chapter commits an offence and shall, on conviction, be liable to a fine not exceeding 20,000 ringgit or to imprisonment for a term not exceeding 6 months or to both. While if a person who commits an offence for giving false or misleading information, evidence or documents, etc., shall, on conviction, be liable to a fine not exceeding 20,000 ringgit. This section applies to any person if the Commission has reason to believe that the person has any information or is capable of giving any evidence. Notwithstanding the provisions of any other written law, the Commission may, by a written notice, direct any person to give the Commission, within the period and in the manner and form specified in the notice, any such documents, whether in a physical form or in an electronic media. and to make copies of any such documents to the Commission. The Commission may direct any person, no matter the person is an individual, body corporate or a public body, or the person is a partnership, to appear at a private hearing before the Commission at a time and place specified in the notice to give any such evidence. A person shall not make a record of any matter or thing in such manner that it does not correctly record the matter or thing. Next, the Commission shall maintain a record of all information, evidence or documents received. The Commission may or may not publish the information received, depends on the situation. Now, let's move on to the Chapter 6, Register. The Commission shall maintain a register, in both physical form and electronic media, of all matters which are required to be registered under this Act and its subsidiary legislation. If a person requests that a copy be provided in an electronic media, the Commission may provide the relevant information on a data processing device (OI) by way of electronic transmission. Chapter 7, Notification and Resolution of Disputes. A dispute between two or more persons, the parties, regarding any matter under this Act or its subsidiary legislation shall first be attempted to be resolved by negotiation between parties. Step 1. A party to a dispute may, in writing, notify the Commission of the dispute. After the Commission is notified in writing of the dispute, the Commission will act to resolve a dispute. The Commission may publish guidelines setting out the principles and procedures in resolving disputes. Then, the Commission may resolve the dispute upon such terms and conditions. The Commission shall provide the parties to the dispute with a copy of its decision as soon as practicable. Lastly, the Commission shall register all decisions it makes. The content of the register will be discussed in the next slide. The register shall contain the names of the parties to the disputes, a general description of the matter pertaining to the decision and the date of the decision, but not terms and conditions of the decision. Chapter 8, Registration of Agreements. The parties to a written agreement shall apply to the Commission for the registration of the agreement. The Commission shall register the written agreement if the Commission is satisfied that the agreement is consistent with the object of this Act, any relevant instrument under this Act, and any relevant provisions of this Act or its subsidiary legislation. An agreement shall only be valid and enforceable upon its registration. Here comes to the end of our explanation about the powers and procedures of the Malaysian Communications and Multimedia Commission. Thanks for watching this video.